out in one of the trucks with the defendant?
Yes, I have ridden in his truck before.
How often?
A couple of times. I wouldn't say like super often, but definitely.
Welcome back to the Law&Crime Network, everybody. This is Jesse Weber. That was the testimony of Chad Carrizales in the Jason Riley King case out of San Diego, California, where about that former Marine who is accused of drunk driving and driving on the wrong side of the highway, resulting in a head-on collision that killed 2 people and injured 3 others. We talked about it earlier this morning. We expect live coverage at around 12 p.m. Eastern Standard Time, and we'll make sure to cover it as soon as we do have a live feed. But right now, I want to focus on another case we're covering here on the network. This is a case we keep previewing as well. It is out of Titusville, Florida, and it's also a case that's in jury selection right now, but we anticipate live feed maybe tomorrow or next week. This is the case of William Woodward, who is accused of shooting and killing his 2 neighbors and injuring a third on Labor Day weekend in 2012. It is alleged that he dressed in camouflage for a surprise attack, hid in the bushes, and this was apparently all captured on surveillance footage. Now, that's not the only interesting part about this case, because his defense attorneys are claiming self-defense, that this was a justifiable homicide. In fact, his defense attorney has said that there are those in the community who support the actions of Mr. Woodward. And that's not all. That's not all. This is a death penalty case. There's a lot at stake here, including the fact that Mr. Woodward may, in fact, suffer from PTSD and a brain injury. He was a war veteran. So we're going to talk about all of that and all the different aspects in this case, because there's a lot to discuss, a lot of interesting factors. Right now, I'm joined by criminal defense attorney David Pietro. David, I'm glad I have you here to talk about this case. It's another interesting one. The idea that this might be a justifiable homicide case, but then I'm also reading that this guy did a kind of surprise attack from the bushes in camouflage. Doesn't that kind of not reconcile with each other?
Yeah, this is typical Florida, right? This is what makes Florida.
You said it, I didn't. You said it, I didn't, David.
I live here, so I know.
You have the license to say that.
It's the warm air and from everybody coming from New York causes a cataclysmic destruction down here. This case doesn't seem to be a stand your ground type of situation. Here in Broward County, which is a little south of Brevard County, we had a police officer that was able to use his stand your ground, but he had shown up to a crime scene with somebody who had a pellet gun that had appeared to be a actual firearm. He had headphones in, and the officer ended up killing the person, but was called out to the scene on a 911 call. That's stand your ground at its clearest. Even though he was charged clearly under that scenario, there was zero premeditation. He found himself in a situation where he needed to use his firearm and take somebody's life, unfortunately. This case is I think the PTSD is probably a better defense, because we're learning now that through the NFL players that this thing called SIDS and his brain trauma that can happen to military men, it extends not to just to the NFL, but to military men and women, and it causes this neurological damage. It basically slowly changes a human being to deteriorate over time. That's probably a better defense on the premeditation. Seems like this guy is going to get convicted, more likely than not, very more likely than not. But to mitigate the death penalty, I would probably focus under the facts under that angle, other than the angle of stand your ground, which still has some level of objectivity that you need to prove.
Well, obviously, you know, we don't know the facts, the whole facts of the case. The trial hasn't started yet. But the idea here, that's an interesting point. If the defense can show some sort of PTSD, how does that work exactly? How would you flavor that? Would you say that he had an interpretation that his family, that he was in danger from the 2 victims in this case, Gary Hembry and Richard Pecor? Or is it kind of the idea that, wait a second, is it an insanity kind of defense? Like, how does it work if you suffer from PTSD and a brain injury? How does that flavor work there? Is it saying that he in his mind, he thought he was justified? It becomes subjective. How do you flavor it as a defense attorney?
Yeah, it's tough down in Florida. We have a very hard level of legal measure that you need to get through for insanity. For insanity, you basically you need to think that you're in Disney World and you're riding a roller coaster and you end up actually having a gun and kill somebody. It's not PTSD is not going to work for that, but will work where it could work, I should say, is to the level of premeditated murder and as a mitigator to the death penalty. Because if he has neurological diseases in his brain, and they could prove that, then they could probably disprove maybe some of the premeditation. But it doesn't really matter in Florida whether it's first degree murder or second degree, because since he did it with a firearm, we have what's called 10/20 life, and if it's second degree murder and they prove that he used a firearm to do it, he's getting life. I mean, life in Florida is life. You come out in a pine box. You don't come out ever alive. So the prosecutor has a lot more leeway to try this case, because chances are he's going to get life. The question is whether he's going to get death. So the prosecutor has very little to risk. I mean, this is one where they can go in with a lot of confidence and really they can aim for the moon, or aim for Mars, but they're definitely going to hit the moon. So I can see why they're trying this case.
It's interesting you said that, because we've covered other cases on here where people save that kind of arguments about, oh, my client suffered some sort of traumatic brain injury. Let's talk about his past. Let's talk about the injuries they suffered, but they save that for the sentencing phase. You don't really see it during the guilt or innocent phase. So it's going to be interesting to see. But what the defense attorney for Mr. Woodward is saying here, or at least the flavor of it, is that there was ongoing provocation that for him and his family from the two victims here, Gary Hembry and Roger Pecor, for months. Now, if he can also show that the community, apparently he keeps saying that the community is going to back up Mr. Woodward's actions, does that have any sway? I mean, these guys, Gary Hembry and Roger Pecor, could have been really mean and harassing and all that, but if they didn't present a deadly threat at that moment, doesn't all that not matter?
Yeah, I could see this defense working if there was some sort of provocation and they had met each other in the middle of the street or on one of each other's property. It was more spontaneous between both of them. They were both being hostile and aggressive. It rose to a level on the other side where the Woodward would need to then use deadly bodily force to defend himself with a firearm. I could see that defense working, but this whole like him putting on camouflage and going to their house where they're having a barbecue, I mean, it's really overstretching the obvious. I mean, I don't think he's going to have a likely defense under stand your ground. He could have called 911. He could have moved. He could have not gone there at that moment. He put himself, I don't even want to say he put himself in it, because I really think the facts are that he intended to kill these people. So it's not one of these circumstances where he put himself in, he's in a situation where it rose to the level that now he needed to defend his life. It just doesn't appear that way. I mean, yes, these people hated each other, but I don't think you can juke the position all these days and days prior, months and years, and kind of cobbling and like I felt like I needed to kill them. I mean, if we stretch the law that far, I mean, a lot of people are going to be able to kill people in Florida. It'll be even crazier than it is that we already have it to this day. Yeah,
I mean, people kill each other for all sorts of reasons, and you could say, hey, that was provocation from something somebody slighted you for years ago, or months ago, or weeks ago, or days ago. The thing here is he's charged with 2 counts of first-degree murder. So when we talk about that premeditation, if it's true, based upon the allegations, that he dressed in camouflage and hid in the bushes for that surprise attack, that's just the definition right there, right, of a deliberate pre-planned murder.
Definitely. And you got to remember, Florida's stand your ground, what it really did was it took away the requirement to retreat. So it used to be, in order to prove self-defense, you first had to prove that you had no ability to retreat. So it was the objective standard. Now it's more of a subjective standard, and there's no, even if you could retreat, you could still maintain stand your ground, because under those circumstances you needed to use deadly bodily force to a firearm, and that changed the parameters of the law. So to take the requirement of proving retreating away and putting under this factual scenario in this case, It just doesn't make a whole lot of sense. So I think they're overstretching what stand your ground really stands for. And really, you're allowed to stand your ground. I mean, literally, that's why they called it that. And that means you don't have to retreat. If you're there under that circumstance and you're presented with deadly bodily force, and it's reasonable that you believe it, then you can then assert that defense.
Yeah. David, I would like your thoughts on this. So we talk about the fact that Mr. Woodward was a war veteran, and we talk about this PTSD. Woodward testified in a stand your ground hearing that he has PTSD from the Gulf War, but the prosecution pointed out through their research that they found he was never in combat. Does that not necessarily, does that mean he can still have PTSD? Can he still use that even if he wasn't in combat? What do you think about that?
Well, I guess define what combat means. You know, I mean, you see some veterans that come out and they were in heavy combat. It never really affects them, and they go on their lives and they can deal with it. And then you have some that were sort of in the periphery of combat, you know, bombs exploding nearby and things like that, and they come out really severely damaged because of it. So
Yeah.
how a person digests war and the stress and anxiety of possibly being wounded or killed, every person absorbs that kind of stress differently.
Okay.
So I still think PTSD, if they have good experts, could be a good proffered defense. I think saying he's not in combat, you know, that cuts both ways. You know, he still was in the military. He still was in Iraq. I think that just because he wasn't in combat, there's still a lot of room to explain what PTSD is to a jury.
Right, right. And the other part about this case that's an interesting aspect is that apparently this whole shooting was captured on surveillance footage, okay? So how much do you think that's going to play? And by the way, we've had cases before where, you know, we've seen cell phone evidence, we've seen surveillance footage. It's not that clear. The clarity of the actual video is not that clear, so it's kind of hard to determine what is what. But you have to say that would help the prosecution, no?
Oh yeah, videos. I mean, and photos. All those things, but videos in particular of a crime, they only cause the jury to really vividly understand what happened at that moment. It only helps the prosecution. I had the pleasure of actually sitting on a jury. It was a misdemeanor battery case about a month ago, and there was a video, and it changed the dynamics of the case. So actually seeing that video, it really, even though we found him not guilty, it really changed the understanding of what happened in that scenario. So I think video is going to only help the prosecution.
We covered the Ray Tensing case out of Ohio where, and David, I don't remember if you and I had talked about that case, but it was the idea where, you know, they had the body cam footage showing exactly what happened. The officer Tensing coming up to the car, speaking to Sam DuBose at the time, you know, speaking to him about what happened. And then all of a sudden, that like fraction of a second determination of did he step on the gas? Was he trying to drag the officer? The officer took out his gun. You know, that split second, that 2 seconds, even I don't even know if it was 1 second that we had to determine what was happening. At the end of the day, there was a mistrial, 2 mistrials there, and I wonder how much that'll play here. You know, what will the surveillance footage show? Will it maybe help the defense at some point? Isn't it possible?
It's tough because he was on their property when they were having a barbecue. Right. So I think for Officer Tensing, it was a little different because it showed, for him, it actually helped the defense because it shows how quick that whole case developed. And so how the evidence comes out through testimony, you would in your mind would think it was a protracted event, but when you actually see it on video, like, wow, that was like milliseconds of forethought and consideration on both sides. So I think for this case, though, I mean, I hate to say that people are going to win or lose. They have the right to a trial, but I think this one's a slam dunk.
Well, I will tell you, watching those opening arguments, which you expect maybe tomorrow, maybe even starting next week, I think it's going to be great. I think those opening arguments from both sides are really going to be something to watch, particularly from the defense about how they frame this, because this is a really, as most of the cases are, it's an interesting case, but also a horrible case when 2 people are killed and a 3rd is injured. So, David, we would like to have you back on to talk about that one. David, I want to keep you here if you still have time, because I want to just get your final thoughts on about the Jason King case. What I'm going to do is play a short clip again of Chad Carrizales. This is the continuation of his testimony, that U.S. Marine. And then you and I would like to talk a little bit about what you think about this stand-down presentation that the Marines attended. So we'll talk about that in a minute. Stand by, David. In the meantime, I want to play the clip of Chad Carrizales, the U.S. Marine, who testified yesterday in the Jason King case. Take a look.
How long do you think the group of you stayed in the hot tub?
Probably anywhere from 30 minutes to an hour.
Where did you go then?
As far as I believe, back up to the room.
When you got back to the room, approximately what time did you leave the gathering?
I think it was about 10 or 11.
And when you left, who did you leave with?
I left with Mr. Slime.
And was Mr. Stein driving again?
Yes.
When you left, was Mr. King still at the gathering?
Yes, we all kind of left. People that left kind of all left at the same time.
So when you left with Mr. Slang, is it fair to say that the defendant also left at the same time?
Yes.
Through the course of the evening that you were at that party, from about 5 p.m. on, how much did you see the defendant drink?
Except maybe 2, 3 beers.
When you left the party, did anyone question whether or not you were okay to drive, or whether Mr. Slang was okay to drive?
Mr. Slang had been drinking, so there's no issue there.
Did you see anyone asking other people whether or not they were okay to drive?
I don't know.
Did anyone offer you to be able to stay at the hotel if you wanted?
Yes, both his parents had offered. I'm not sure when, beforehand, we were welcome to stay the night if we wanted to.
And who was that offer open to?
Everyone, as far as I know.
When you left, did you have any sort of conversation with Mr. King about where he was going?
Yes, he said he was going to meet up with a friend at some bar.
And did that cause you any concern about continuing to go to another bar?
No.
Have you been out besides that one evening, in a social atmosphere with Mr. King before?
Yes.
And have you been out with him before when he's been drinking alcohol?
Not out. I wouldn't say like out. What do you mean by out exactly?
Going out off base, somewhere drinking
No.
alcohol. Have you been on base when Mr. King's consumed alcohol?
Yes.
And that's permitted on Miramar?
Yes.
How often would you say that you've consumed alcohol with Mr. King?
Maybe a handful of times.
Besides working with Mr. King and going out with him a handful of times, would you say that you had a close friendship? Did you do anything else together?
There was times that we hung out in the barracks, we watched movies, or went out, did things. I'd say it was pretty decently a close friendship.
When you were hanging out with all the group of you at the hotel, how much alcohol was at the hotel for you guys to drink?
I'm not sure.
And did either you or Mr. Slang bring any alcohol to the function?
No.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. That is the testimony of Chad Carrizales, who took the stand yesterday in the Jason Riley King case out of San Diego, California. Now, what he's testifying to is the fact that Mr. King, him, and all the other Marines attended a stand-down presentation at their base, which was when police officers would instruct them about the dangers of drunk driving. Let's talk about how that plays into this case. Again, I'm joined by criminal defense attorney David D. Pietro. David, everybody knows the dangers of drunk driving. Does this really matter, this kind of testimony that they attended a presentation about this?
Yeah, I think it's overkill. And I think, honestly, it probably highlights the fact that he was in the Marine Corps, which probably, we're not realizing it, they're actually helping him. And so I think this is overkill. We all know drinking and driving is dangerous. We all know when we sign for our driver's license about informed consent and how we consent to a breath or blood or urine specimen if there's suspicion of that you could be driving under the influence. So I really think it's overkill, totally not necessary.
Then again, here, I'll give you the flip side. If he attended this, I think it was reported 8 days before this collision took place. Couldn't you say that this is a guy who even knew better than most people? He should have been fresh in his mind about the dangers of drunk driving, and he still did it anyway. Is that still change the idea of this being second-degree murder at all? Does that enhance it or support it in a way?
Yeah, I guess so. But really, I don't think the jury's going to decide on that. I really don't. I think the jury's. I think there's a strong argument. Is how do you develop intent while you're inebriated? So as you become more and more intoxicated, the level of intent becomes less and less found because how does a drunk person do logical and rational things? That's the problem with alcohol, and that's why it affects driving. So I guess it's a little nugget for the prosecution, but I don't know if it's going to be like the home run that they intended to be.
Now, David, we keep talking about it, the fact that Mr. King was a Marine, okay? Do we hold him to a different standard? Do the jurors hold him to a different standard and say, if anybody should have known the difference between a right or wrong, it's a serviceman, it's a Marine who should have known this? Do you think that goes into their factoring of their way they think?
No, because I don't think we look at our armed forces the way we look at our police officers. I think that's a great argument. If he was a police officer, he would really get fried. But since he's a Marine, Marines are younger. The country, for large part, respects our service men and women. We understand that they endure a lot of stress for a position that pays little money. And it's a duty and an honor. So I don't think that if he was a general, maybe, but just as a standard Marine Corps soldier, I don't think that pushes over like it would if he was a police officer or something like that.
That's an interesting perspective, yeah. And these guys are young that are taking the stand. They are young. You hear about them. And I mean, you just saw Chad Carrizales, young guy. I mean, thinking about it, and everybody knows that everybody's drinking, having a good time, but when it crosses the level, that's really where it becomes an incident. And I'm curious. We keep seeing testimony. Keep seeing witness being brought forward. When the defense has their case, what kind of witnesses do you expect that they will bring out, if any?
I think they're going to try to mitigate whatever witnesses that were there, playing pool with him that night, doing whatever he was able to. I've tried, when I was prosecutor, I tried a lot of these DUI cases. They are not easy. And I used to always joke and say trying a DUI is like trying an armed robbery, and your jury pool are armed robbers or used to commit armed robbery, because everybody has maybe had one too many drinks. Well, most people had one too many drinks in their lives, and they drove and they got lucky. And so you have a different jury pool. You have honest, law-abiding people that may have been lucky to not be in that situation. So I think what you'll hear is was he able to talk? And I think he'll have witness that, yeah, he was communicating, he was talking, we were playing pool. Was he able to hit the ball when he was playing pool? Was he able to pay for his tab? Was he, did he walk out? Did he stumble out? I mean, it's, if he knew how to handle his alcohol, which a lot of people do that get involved in DUIs, they are pretty functional, and that you can mitigate a lot of the issues of DUI on basic testimony. So I think you're going to see people that he was around that night are going to testify that he was able, even though they might say, oh, we told him don't drive. Yeah. I think a good defense attorney will say, was he able to pay his tab? Was he able to do X, Y, and Z, right, find his keys, and all those kinds of things, and try to mitigate it?
Do you think there's also, you just touched upon it, how many people told him not to drive, don't do it? You're really going to get into the details of that conversation, I imagine. Did you really tell him not to drive? What did you tell him exactly? How did you tell him? Did you really think it was that serious? Was it more of a question, I imagine, of, hey, listen, don't drive, I'll drive you? Or was it really like, hey, stop it, don't get behind the wheel? I guess that determination is going to really come into play.
Right, and then I would, if I were the defense attorney, ask him why didn't they call the police, right? Yeah. If they knew he was so inebriated and he was so dangerous that it rose to the level of potential murder, why didn't you call 911, or why didn't you take his keys so that he would have just got a DUI, and killed some people? So I would kind of cast them in a bad light in a way, and that they were the ones giving him the alcohol, the bartender, and that they are actually culpable. And I'm sure there's civil lawsuits that I'm sure these folks have been sued. There's no question about it. So I would try to paint and cast them as quote unquote unindicted co-conspirators. And
also in the sense that it obviously wasn't as bad as you're claiming now. He wasn't as drunk as you're saying he was back in that night. If you really thought it was a problem, like you said, call him an Uber. I'll drive him, something else. So that's the way that you think the defense is going to flavor it.
Definitely, and I would ask him, when did you say he couldn't drive? Was it drink 3? And did you give him drink 4, 5, and 6? So it really is you could really cast somebody in a bad light that tries to be the saint after the fact, and maybe they got sued, or they're worried about being sued, or there's financial issues, and they're saying this now and making it up to mitigate their potential civil liability. Yeah. So I think a good defense attorney could really beat a bartender up that served drinks, which ultimately resulted in the death of 2 people.
Right. David Pietro, thank you so much for coming on to talk about this case. You provide a really interesting perspective on something that people would see as a slam dunk, clear, black and white, but I'm glad that you provided a little bit more color to this because it is an interesting case, second-degree murder charges in this kind of DUI case.